U.S. Supreme Court is about to deliver an opinion that could undo the law that many believe made the internet possible. Today, we'll unpack what it all means and how it may affect your business. Welcome to the Day 2 Podcast. I'm Jason Boyce, founder and CEO of Avenue 7 Media and host of the Day 2 Podcast. Today's topic, the Supreme Court case Gonzalez versus Google, a case that questions the protections offered to big tech companies by Section 230 of the Communications Decency Act. Our guest, John Bergmayer, is here to help us make sense of this case and how its outcome may impact Amazon, social media, and your business. John, thank you for joining us today and taking time out of your busy schedule to help our listeners understand what the heck is going on. How are you today?
I'm great, and it's great to be here. Thank you for having me.
Yeah, my pleasure. John, let's start. You're probably as well snapped in with this little known, was it 26-word section of the Communications Decency Act, more than anyone I know. How did you get involved? Tell us a little bit about you and how you got involved in public knowledge. Let's start with that.
Sure. I was actually just interested in tech policy and the basket of issues that public knowledge works on, kind of like prior to going to law school. So I was just like really fortunate that pretty early on, I was, directed to public knowledge where I worked as an intern during law school. And I eventually, ended up coming back as a full-time employee. But really, I was interested in the issues because I've always seen the potential of technology to really enable human creativity and art and culture. And, that was really what motivated me to be interested in technology, that sort of like intersection of like how technology and the arts work together. And then, working on a lot of like digital issues, digital copyright issues and so forth at law school. And then at public knowledge sort of, fed into that pre-existing interest. And of course, once you're in the game, the tech policy business, as I ended up being, you end up, studying the area pretty broadly. And I think this question of what the scope of liability should be for online platforms, it really became controversial relatively recently as these things go. I mean, it was litigated right away, but I think it was really people started to look at Section 230 with various ideas of how to perform it or new interpretations of it right around when social media and big tech just became such a big part of our lives. I think that was really like the genesis of when people really started to pay a lot of sustained attention to it. And that's probably about the time that I became more interested in it too, as opposed to just it being like one of the various laws you know about, but aren't really a hot topic. So I would say that's like my little biographical story of how I became sort of interested in it. It's one of these issues that sort of bubbled up along with the dominance of the tech companies, I believe. It really has had a long life without any scrutiny. It was a good law. I think everyone in the internet agrees that at the time this thing came into existence, that it was absolutely necessary. And I don't think that we would have the internet that we have today if it wasn't for this law. Is that a fair statement? Do you agree with that, or do you feel differently? I would say that I mostly agree with it. Very often when you have a new technology, a new industry, and there's litigation around it, a lot of times the early cases don't make a lot of sense, and it takes a long time to sort of like piece it together. And hopefully like the legal system, the liability regime like develops along with the industry. What happened was there were a number of just like really bad court decisions right when the internet was seen as like this like new sector of growth for the economy. And these decisions effectively had like a result that almost no one wanted, which is to say that if you just have a website and you just are totally hands off and don't moderate any content, then one court said, well, that means that you're not going to be liable for it. If you just sort of just like hands off, don't look at it, don't edit, don't moderate, you're just like a passive receptacle. Okay, you cannot be liable. And then another court said, as soon as you take down something that's bad, like someone posts something that's hateful or harassing or incorrect or anything, why then you are just like a newspaper and you are therefore liable for like anything. And it's like, okay, so either you do nothing or it's like you're liable for everything as if you were a newspaper. And that doesn't make sense for the internet at all. And Section 230, I think, was a balance of saying, well, how about this? We're not going to have those like years of litigation of figuring out, eventually coming to the right answer. We already know what we think the answer should be, which is that the people who say things should be liable for them, and then the platforms that host their speech shouldn't be. And at the same time, we do want platforms to be able to moderate speech without, doing so being like this hazard where all of a sudden you could get like sued into oblivion if you try to do it. So that's basically the dynamic that Section 230 was trying to respond to. How do we have platforms have some responsibility for what they do, but aren't liable for all of it. And Section 230 was the response at the time.
John, I'm going to go through a little timeline here. Feel free to jump in and correct me.
Sure.
Like I said, nobody knows this better than you. So 1996, I did a little Googling ahead of our podcast this morning. In 1996, which, largely the dawn of the internet age in many ways, certainly the commercialization of the internet, the Communications Decency Act, I've been calling it Consumer Decency Act for years, John. Thank you for setting this straight. That tells you where my mind is. I've been selling stuff on the internet for 21 years. So, but the Communications Decency Act and this section 230 was passed by Congress. 26 words of this section stated, basically, I'm paraphrasing, that websites are not publishers or speakers and cannot be sued for defamation like newspapers. Instead, this law proclaimed that websites are more like telephones, where no matter what is said on the phone, owners of the phone lines could not be sued. Is that fair? It was starting in 1996.
I think that you have it mostly right, but with one very important clarification I'd like to add.
Please.
Which really honestly is the source for just like a lot of the misconceptions about Section 230. And it's really just about the very terse way that it's written. It doesn't say that websites aren't publishers or speakers. They are. It says you cannot treat them as publishers or speakers for liability purposes. So what we're not saying is, when you sue a newspaper as a publisher of, say, a defamatory statement, right? You can sue the newspaper, or if it was a letter to the editor, you can also sue the editor, the person who wrote the letter. What 230 says, not that as a factual matter, websites aren't publishers. It's just saying that the traditional kinds of things, you can't sue them for publishing. Like, in other words, the activity of publishing, provided it's third-party content and not their own stuff, which they're liable for, you can't sue them for. And the reason why this is like an important distinction to make is that a lot of people seem to think that, well, Section 230 says that you can choose to be a publisher or somehow choose to not be a publisher. And once you make that choice, you're either liable or not. And Section 230 doesn't say anything about that. It says, go ahead and publish all day long. You're a publisher. We're just saying that as far as the court system is concerned, you can't be sued for publishing third-party content. It doesn't say that they're not factually publishing it, because they are. They're bringing the material into the world in the same exact way that a newspaper does. It is publishing. It's just, it's a matter of, okay, well, we want to let you do that without saying that you could be sued because we just think it's an unmanageable burden, too many comments from too many people.
Did I understand you correctly earlier where you said if a publisher, a website does moderate some of the things that are on, now they all of a sudden flip over and can become liable as a publisher?
No. It's the opposite. Yeah, so that's the misconception that people have. In other words, if you read Section 230 to say that websites aren't publishers, then what people say is, well, if you're a website that is publishing, therefore Section 230 doesn't apply to you. And Section 230 doesn't say that. It says that no interactive website can be sued as a publisher. It doesn't mean that they're not a publisher. It just means you can't treat them as a publisher in a court of law, which is just saying, so things like defamation. In other words, like you can't sue Twitter because someone posted something defamatory, even though Twitter is publishing that defamatory tweet in the traditional common law sense. It's just saying that because of this statute, you can't bring them to court over it because we've decided that, having liability in this circumstance, given the nature of these interactive websites, it would just not really be a sustainable system.
Got it. So in that example where you're talking about Twitter is acting like the telephone company. They're simply providing the platform for people to have some sort of communication or some sort of statement that's made about one or the other.
Well, as far as the law is concerned, yes, but there's nothing in the law that says that websites can't have an opinion and they can't express that opinion through their content moderation decisions. So, for example, I can run a political message board that accepts comments from anywhere on the internet. Section 230 would apply to me just like it would apply to Facebook or Twitter, but I'm free to just delete everything I disagree with, and that doesn't mean I become liable for what I've left there. In other words, like I can delete everything I disagree with. You're going to know just factually, like, okay, well, this guy seems to delete everything he disagrees with, so we know what his opinion is. But Section 230 says I can't be sued for that. If you run a website, you can't be sued for moderating content. Even if you are expressing a point of view through that moderation. The First Amendment also protects the right of website operators to have an opinion. So while I agree this, like, legally speaking, you might want to say that Twitter is more like the telephone system. They're providing a tool for people to talk. You don't hold the telephone necessarily liable for providing that tool. That's absolutely true. However, there is no obligation on Twitter or on any website to somehow be neutral or unbiased or fair to liberals or fair to conservatives. I mean, the law just doesn't speak to that at all. And it just simply says that websites can just go about being publishers and not be sued for being publishers. And a lot of people don't like that policy choice, but I think that is the best way to understand what the policy choice that was made is.
Interesting. It's complicated, John. It's not simple. It's not.
I know.
Binary.
Sometimes it seems complicated, but I do think sometimes examples help.
Yes. Right. So let me ask you a personal question.
Sure.
Section 230. Is this a good thing today? Is it well written enough to cover today's issues that we see day in and day out?
I think that the law is clear, and for the record, since we talked about the Gonzalez case, I think that Google should win on this case. I don't think that the argument that the petitioners at the Supreme Court are putting forward is the right one. That being said, Section 230 is just a statute. Congress can and does change statutes all the time. It has actually changed Section 230 relatively recently, and I think that there's some areas where A, it could be changed, and B, there are areas where if court cases come out a certain different way, then I would advocate for changes to undo that. So I think there's lots of examples where we can and should change the law to increase platform liability. That being said, on balance, I still do think that Section 230's balance is the correct one of saying that, here is the scope for liability for websites. Here's the scope for liability for users. I do think that rough balance, is still correct, but I think that there are definitely tweaks that need to be made.
Got it. Okay, so now let's fast forward. 2015, ISIS terrorists kill 130 people in a Paris terrorist attack. Included in the dead was Noemi Gonzalez, a 23-year-old American student. Noemi's parents believe that the law, Section 230, should not protect social media companies, and it's not just Google. I think they included Twitter and Facebook in that case. Is that correct, Don?
This particular lawsuit is against Google. There is another related lawsuit against Twitter right now.
Okay, got it. So Noemi's parents, Miss Gonzalez's parents, believe that the law should not protect social media companies who they believe aided and abetted terrorists like the one that killed their daughter in Paris. And the reason they think that is because of the algorithms. Is that fair to say that they believe that whoever was involved in these terrorist attacks in Paris were radicalized by the social media platforms, that they clearly were following, tweeting, following YouTube channels, creating YouTube content, etc. Do I understand the Gonzalez parents' complaint correctly?
Yes, absolutely.
Okay, got it. You spent a career tracking this Section 230 and paying particularly close attention to this case. So I can understand, John, we've got this platform. People are going to go in there into forums. They're going to say things about stuff and about each other. And it seems to me fair that Section 230 would protect the platform that's doing it. However, when you start to add artificial intelligence into the mix, and somebody who's an otherwise well-meaning citizen of another country, they start to see over and over again the negative. And maybe that citizen is in the United States, right? And maybe they start to get served this information and this data that's increasingly negative, that potentially changes their outlook and view of the world. Once you introduce that piece, do you still like Section 230? Or is that the core of this case? And what are your thoughts on the algorithms that so many people have complained and some feel, John, have really torn at the threads of the society that holds society together?
There's a lot of merit to those complaints and to those observations that you just made, and that the better way, to change policy is usually through Congress and not the courts. And the reason here is that, with utmost sympathy, to the Gonzalez petitioners, and without even getting to the question of, it's like, okay, without Section 230, would there be liability, right? Because that's another tricky portion of Section 230, which to non-lawyers is not intuitive. Just because you get rid of a liability shield, it doesn't mean there's liability. So in a lot of these cases where people want to get rid of Section 230 and you'd say, oh, I'm going to sue Twitter, I'm going to sue Google for this. It's like, okay, well, Google or Twitter is still going to win. It's just going to be more expensive for them. And they're basically going to win because they have a First Amendment right to moderate content on their platform. Section 230 just sort of shortcuts some of the litigation.
What you're saying is Section 230, whether it's here or not, it doesn't prevent a family like the Gonzalez from suing Google, claiming that they radicalized the person that killed their daughter, right? They're not, Section 230 is neither here nor there. Whether it's here or not, that family can still sue, and you still feel strongly that they're going to lose because it's a very high bar to prove. Is that what you're saying, John?
What I mean is the litigation right now is over Section 230, and you have to get past that before you do anything else. Right. So you have to decide whether Section 230 applies. And it's like, if you decide Section 230 does apply, case over. You don't even get to the facts. You just get to whether or not there's a liability shield. The liability shield is in place, then we don't look any further. If instead the conclusion is that Section 230 doesn't apply here, it's like, okay, now we're on to phase 2. Okay, in a world without Section 230, a website has terrorist videos and then someone watches them. Okay, you're going to sue them over what theory? In this case, it works a little better because ISIS is a designated terrorist organization, and there are special laws which more apply in the Twitter case, which say that you can't provide material support to like a certain list of organizations, that have been provided. I would say all this aside, the question of support to terrorists, but just looking at this, the actual theory that the Gonzalez plaintiffs have put forward is that, well, once a video is recommended, then we are saying we're not holding you liable as a publisher. We're saying that recommending is something different, and we're holding you liable for that. They're also saying, well, if you just had the video just somehow on YouTube, like someone uploaded it and it's there for someone to go and see if they know like the URL, we can never sue you over that. They're saying that. But they're saying that this other stuff, like the recommendation and like the way that content is organized on youtube.com, and you watch this, you want to watch that, and here's playlists. They're saying doing things like that is not protected by Section 230, right? So they're trying to draw this distinction. And it is, frankly, in my view, an imaginary distinction. There really is not a distinction between hosting a video and recommending it or promoting it. It's all just like different ways of saying the same thing. And at a certain point, it's a matter of degree. So I believe that the behavior that is complained of in this case is protected by Section 230. It just like the recommending of videos is just one form of publication. And then the second question is, it's like, okay, but that doesn't actually answer the question. I'm just telling you what court should do with the statute as written by Congress. That doesn't say what Congress should or should not do. It doesn't say that Congress can never look to the question of algorithmic amplification and radicalization, and it absolutely should. The way the Public Knowledge, my organization, we support a much more comprehensive approach. We think there should be a digital regulator. There should be algorithmic accountability and auditing, and a much more sort of nuanced, holistic approach, I suppose you would say, as opposed to waiting for a particular bad thing to happen. As, here in the Gonzalez case, this content that Google is recommending, it was against their own terms of service. Like, it shouldn't have been on there, but they just weren't able to, they didn't have the ability to get it down in time, and it ended up being recommended. So instead of litigating on these like specific instances, I think just a better approach to this question of algorithmic accountability. And that's because it has a lot more than just, questions like this, defamation or radicalization. It has to do with people's credit scores. It has to do with, whether or not you get a job. It has to do with whether or not, you get an apartment approved. Increasingly, there are these black box algorithms that aren't just, as we all know now, just generating content and just like spewing it out on the internet, but also making decisions. So we absolutely need like really strong accountability for that kind of thing. And yes, that absolutely would include content recommendation algorithms and things of that nature. So that's certainly one approach that, that I would recommend that policymakers look at for reforming sections, or not reforming Section 230 per se, but on the broader question of tech accountability.
I love it, John. I couldn't agree more that legislating and protecting citizens in this way is a much more effective way than going to a Supreme Court and asking for them to overturn existing legislation. I couldn't agree more. You guys at publicknowledge.org recommend a digital regulator and then algorithmic regulation. And, a lot of our listeners are Amazon sellers, and there's no bigger black box than the buy box algorithm, which determines who is a winner and who's a loser on the platform. Let's talk a little bit about Amazon. And so ahead of the interview, I was thinking a lot about this idea of recommendation engines and liability. And I remember a state Supreme Court case in Ohio where a young man purchased a supplement product on Amazon. There were, I don't know how many times the legal or a limit for caffeine was in the product. The parents lost their son, dying as a result of taking this product. The parents sued, went all the way up to the Supreme Court in Ohio, and the Ohio judge said, I feel for you, I understand it, but according to state law, there's nothing we can do about it. So coming back to Section 230, in your mind, should Section 230 protect Amazon from responsibility of what gets sold on its platform?
Right. That's a very good way to put it, because I don't think Section 230 should, and to an important degree, I don't think it currently does. So the question of whether Amazon is liable in a particular state, like you said, it's going to depend on the particulars of state law.
Right.
And in different states, even if they have the same statutes, they might interpret them differently because the state court systems have come to different conclusions. So it's very difficult. But I believe that holding Amazon liable as a seller is not the same thing as holding it liable for basically the content that third parties put on the Amazon.com website. I believe that content in general, to the extent that it is provided by a third party, such as an Amazon seller, that content is almost certainly going to be protected by Section 230. And I can see how it's like you'd want to look at how something was listed versus what was sold. Like, that's obviously relevant to an extent. All I'm saying is saying that if Amazon is a seller under state law, then holding it liable as a seller does not violate Section 230, because that is not sort of like backdoor trying to find it liable for words someone put on a website, as a lot of times, people try to get around Section 230, and it just amounts to just different ways of saying that you want to hold them liable for third-party words. This is liability for an action in the world, the sale of an item. An item was, moved from one place to another, and there are just like responsibilities associated with that are really this, like, Section 230 has like nothing to say about it one way or the other. I believe that there have been some cases in states that I've looked at in an article I wrote a few years ago, and certainly there have been a lot more since, which did find that Section 230 protected Amazon or a different seller. But in each of those cases, like, there wouldn't really have been liability anyway. In other words, it's like once you get to the point where you're saying that they're not a seller, so they're not liable for a seller, and then it's just saying, well, and also they're not liable also for the words on the website. So if you have like the facts such that it's like clearly it is the case that an online marketplace is a seller, and we can talk about what that means because that's not determined at all, then I don't think Section 230 should get in the way. That being said, I mean, this has obviously not been like litigated to the Supreme Court in the way that the Gonzalez case is. This is sort of a little side note. But that being said, I really do think it would be honestly dangerous if you take Section 230, which is really just about speech online and about facilitating speech and who should be responsible for speech, and then that translates not into speech but in the ability to sell dangerous products. That seems to me to definitely take Section 230, in a direction it was never intended.
I think, although I think that's happened. In a case in California. California's Supreme Court was able to hold Amazon liable, and I think the reasoning behind that court case, I think it was a battery operated thing. It caused a house fire.
Yeah,
because Amazon was in effect acting as the retailer. It wasn't just a throw it up there with no regulation, with no content, with no requirements. It was then the California case the plaintiff was able to prove that Amazon was held liable, and so. Obviously, John, I'm not an expert on the law in Section 230. I believe in many cases, Section 230 is defending Amazon because Amazon say, hey, we're a platform. We're a marketplace. We can't be held responsible for what goes up on our website. And in recent years, they're spending a lot more time taking things down for on inaccurate claims, for example, content, if you will, making claims that aren't accurate or true. And so they are acting in many ways as a publisher, or in this case, more of a retailer, probably because of that California Supreme Court case. So if in fact Section 230 is being used, and I think if you look at Amazon's lobbying dollars to try to protect Section 230, I think they think it is. I just want to emphasize something that you said previously. You would say this is a gross, I don't want to put words in your mouth. This is not what Section 230 was meant to do and shouldn't be used in this way. Is that accurate?
Yeah, that's right. Obviously, you have to go in court and make your legal argument and not just say, this is an outrage, But yeah, that said, I believe that Section 230's fundamental purpose is facilitating speech online.
Okay.
And that has, I think, as we know now, that has, plus sides and downsides.
That's right.
But what it was never intended to cover was, just because you're an internet company, you can just do the same things as other companies, but somehow escape regulation.
Right.
So Uber, sorry, you're regulated just like taxi companies. Airbnb in local communities, you can be regulated just like hotels. And with Amazon, you should be regulated just like any other seller. I think one thing that's really complicated here is, to me, the question is whether or not they rise to the level of a seller, then holding them liable as a seller should be fine. But the facts under which you would find someone liable for a seller could vary wildly, and different people have different opinions. To me, and I'm sure all of your sellers are very well aware of this. You just mentioned the buy box. Selling on Amazon is totally different than selling on, I don't know, Craigslist or Facebook Marketplace or eBay. And to me, and maybe we need to have a law or something. We need to have thought about this, but with Amazon, when there's one product listing, they control who gets the buy button. It's like one product listing for every seller. If you dig really deep, you can figure out that there's multiple sellers, maybe shipping from multiple places. And then on top of that, the products are stocked in Amazon warehouses half the time, especially when they're fulfilled by Prime. You get a box that says Amazon. The tape says Amazon on it, in fact. It comes to your building in an Amazon truck with someone, and it's like, I'm sorry, this is Amazon. This is Amazon selling. And the fact that Amazon, internally, and it's books, is saying, well, technically this inventory belongs to a third party. So, okay, that's a nice little accounting trick. I don't really see why that affects whether or not you're liable as a seller, frankly. And it shouldn't relieve you of responsibility to make sure that you're not stocking dangerous products in your warehouse and having your uniformed employees put them in boxes and drive them to someone's house. So to me, that's the Amazon story. Yeah. But I would say how to exactly draw the line between a very clear example on one side of Amazon as a seller versus someone selling on Craigslist. Okay, Craigslist is not a seller. It's just like a forum. They shouldn't be liable. There's something in between, and I don't think there's really clear answers to that right now.
That's a great point, John. And again, it goes back to your original assessment, which is this should be legislated. A digital regulator and algorithmic regulation team potentially that's on the government payroll could help resolve these issues and help recommend legislation that could solve this issue. Yeah. So I do want to go back to one point. I've always felt that one way or another, and I know Amazon has used Section 230 as a shield, and I know certainly the social media companies have, that sometimes aside from legislation, that the courts are a really great way to figure out. A neutral party judge can come in and hear both sides of an argument and make cases. But the Section 230 really prevents some of those law court cases from happening. And so I never understood that, especially with the NASA. It made sense from a business perspective that probably Facebook wouldn't have survived the onslaught of defamation lawsuits if there wasn't this protection. It probably wouldn't be here today. Now, we can have a discussion, a sidebar, whether that's good or bad for society. I think you and I probably both have an opinion on that. But after they reach a certain point where they fill up high-rise buildings full of lawyers and they're very capable of defending themselves in court, wouldn't the courts be a good place to sort some of these details out even before legislation? Or am I putting the cart before the horse?
No, I kind of think you're right. And this is why I certainly count myself very firmly in the pro-Section 230 camp. Yeah. But I don't think it's realistic just to say that the one statute is responsible for the growth of the internet, and without it, we'd have nothing. Because I agree that the particular cases, the CompuServe case, there's a case with Cubby, there are these early cases that were just bad. I agree, they were bad cases. But like, what would have happened if Section 230 wasn't passed? It's like, I think eventually the absurd outcomes would have been noticed and corrected by future cases. And that's kind of how the common law system works. It's like, you kind of don't specify exactly, you just sort of like figure it out as controversies arise. Maybe that could have worked with the internet. But that being said, one note of skepticism is that kind of works like over time, over decades.
That's right.
The internet, so first of all, like, maybe we didn't have enough time with the internet. It's like things are growing so fast that maybe we don't have enough time. Maybe not. I don't really know that. That's beyond what a lawyer can really answer. This is like a counter history here. But also, I would think that that's also why you can't just get rid of Section 230 now, as some people want to, because they say, oh, just let the courts figure it out, and like, yeah, there'll be this. And well, it's like, well, they're kind of too important now. Like, there's a real worry that you could just have like one Supreme Court or appellate court decision that like gets something wrong that suddenly really challenges like certain ways that like the very economy is currently structured. Right. So that's not something you want to do, I think, just like casually and just sort of hope that the courts figure it out.
Yeah, I mean, I don't know where my faith is lower, legislators or courts. I don't know. Maybe it's a tie right now.
Yes, that'll be another podcast.
Yeah, exactly. So John, this has been a very interesting discussion. Thank you. Thank you for, again, being on the show here. I want to switch to your prediction here. Two-part question. Number one, will the Gonzalez family win the Supreme Court case? And if they do, will it affect Amazon sellers in any way at all in your mind? Or will it affect social media in any way? Well, in other words, if the Gonzalez family wins, what are the possible outcomes?
If they win, if they could basically just a lot of what a lot of websites do, including Amazon, in terms of like surfacing and organizing content, they might stop doing, or they might do in a less efficient way.
Yeah.
And, totally granted that, like, I understand if you're a seller on Amazon and you're just dealing with these mystery algorithms that are totally in Amazon's control, you might think, good, no more algorithm. But it's also, the algorithms probably also do surface and help, obscure sellers and content, right? So there's good parts and bad. So, I think in general, if that theory wins, it would just be like unpredictable, because basically quite a bit of how the internet is organized from everything, including search results, for example. If you want to say that once something is recommended, like all of a sudden you're liable for it, it's like, okay, so if you search for something and it's listed first, that seems to be a recommendation to me. You're recommending that this matches what I searched better than the other things. Like search engines don't list results alphabetically, like they're based on giving advice. And yeah, so I think it would be mostly harmful, but I just don't think that the Gonzalez plaintiffs are going to win. I'm happy to make that prediction, and if I'm wrong, feel free and have me back, and we'll explain. But the reason is that even a few of the justices that kind of seems to be like on their side prior to, based on their previous comments and opinions, they asked some of the most skeptical questions up front. And while I think that they were maybe searching for a way to have a dig at the platforms in some way, I do think that the overall course of the oral argument made it seem very unlikely that there was a lot of buy-in to their specific theory. I'm predicting that theory doesn't win. But that being said, what the Supreme Court actually does and says beyond, okay, Google wins here, there might be all kinds of other stuff, because the nice thing about being on the Supreme Court is they can just do whatever they want, and maybe that's a bad thing too. But they can just sort of like come up with new theories and just like put them in their opinion that like neither party even like briefed. And they're, what are you going to do about it? So that might happen too. So I do think ultimately Google wins. It's a big question mark. Like, what else is in the opinion beyond the outcome?
Got it. Well, bold prediction, and you're right. What the Supreme Court decides is anyone's guess in this day and age. I think in courts past, it's been a little bit more predictable. But John, look, thanks a million for being here. Thanks for all your hard work that you do to protect voices online and in the digital world. And I'd love to have you back as we unpack. I don't think this story's going away, John, so it'd be great to have you back on the show so we could talk about next iterations as well.
Cool. Yeah, I certainly love getting our reviews out to new audiences. So thank you for that.
So by way of recap, The internet, as we know it, may or may not have existed today without the protection of Section 230. John, our guest today, has been amazing and helped us understand some of the more nuance. I tend to agree with John. I do like the idea that things can be sorted out in the courts, but I also agree with him that the government has been a little bit asleep at the wheel. I loved his idea about a digital regulator and algorithmic regulation, having experts in the administration and in government who help keep an eye on the solve for these things. In terms of the Gonzalez, my heart goes out to their family for sure. I wish the Gonzalez family the best. Who knows what's going to happen in the Supreme Court's case? But as a seller or as a vendor, it's wise to protect your business by following the law and producing products that are safe. It's also important to make claims that are supported by evidence. Amazon's actions the last few years seem to suggest they know a time is coming when they won't be as protected as they have been in the past. So protect yourself, your customers, and your business first. If you're ready to start growing and protecting your brand on Amazon with a team of experienced Amazon operators, you can visit us at day2podcast.com. That's day2podcast.com. Lastly, if you know anyone else who gained value from this podcast, please share it with them. Thanks for listening and happy selling.